and appeals in the matters of London Borough of Redbridge and Stokes and another and others.
My Lords, Lady, you have before you the appeals and the groups into which they fall as listed in the note which was sent to the court at its request last week, and therefore I hope that I can simply begin by briefly identifying that the appearances before you this morning are myself and Stokes for Walsall, technically for two other claimants, but that's just a quirk of land ownership, which I will ignore. Mr. Anderson, Queen's Counsel, Ms. Caney for Wolverhampton, Mr. Bowes, QC, and Mr. Wolfe for Hillingdon and Richmond, Ms. Bolton and Dr. Pratt for the appellants in the other 8 cases, divided into 2 groups, and up at the far end, Mr. Willers, QC, and Ms. Buchanan, and Mr. Greenhall intervening as they did below for a number of Gypsy and Traveller interest groups. Then line for Mr. Jones in the front row as advocate to the court, and Mr. Kimberlin QC for HS2 is in court, but at present has no entitlement to make oral submissions, though the Vice President's order in his case allows him to seek permission to do so if he elects in due course. Mr. Beglin for Basildon was in a similar position in terms of orders to Mr. Kimberlin, but I understand he's not in court and has left it at...
Can I just raise a few matters, Mr. Giffin, if I may? We may need to go through who's appearing for whom again later. The first thing I wanted to say is that this appeal is being live streamed, of course, and I think it's inappropriate for us to be using Latin. And therefore, I would be very grateful if the case is conducted in English. And you will have to therefore think of ways of getting round your, if I may say so, enthusiasm for Latin tags. Okay, so that's the first thing. And the second thing is, I think it's clear, is it, that the order of speaking is you, Mr. Anderson, Mr. Bowes, Ms. Bolton, followed by, and then you're going to have to help me.
I'm going to have to check the note myself. I think it's then...
I think your note told us who was coming after the various appellants.
It is, however, if your lordships have page 8 in bundle 4, which is the Annex A to the directions, it's then Mr. Willers, in fact, the interveners in the court below. We had put into the annex submissions for the new interveners, Mr. Kimberlin, Mr. Beglin, but subject to any...
They're not coming? No, and then it's the advocate for the court?
Finally, yes.
Finally.
And then, of course, reply.
Yes. Okay, Mr. Jones, Mr. Willers, Mr. Jones, and then reply. Okay, good. Thank you very much.
And the court will also, look, I should mention that so far as Mr. Anderson, Mr. Bowes and myself are concerned, we have permission to appeal. These are simply our appeals. For Ms. Bolton on certain issues, this is a rolled up hearing. She will no doubt deal with that as necessary when she comes to make her submissions. Yes. We also have a provisional timetable and approximate division of issues as between the appellants in the same document we've just looked at. I should say that Mr. Bowes has very kindly ceded 40 minutes of his time to be divided between Mr. Anderson and myself, with the result that I ought to be sitting down at about 12 noon today, Mr. Anderson about an hour after lunch, and Mr. Bowes, I think, shortly after 3 p.m, so that gives the court some idea.
Okay.
And, Lord, since there is plenty of ground to cover, I will, with the court's permission, go straight into the substance. And my submissions are going to fall into two distinct parts. The first, which will occupy the bulk of my time, is concerned with what was called below the first question under issue 1, and it's numbered issue 1 in the note that came to
Yeah,
us.
I don't care the numbers, I do care the substance. Can you just tell me what it is?
Yes. It is, the issue is it correct, as a general proposition of law, that final injunctions may only be granted so as to bind those who are already party to the proceedings?
Just one more question for you, actually. Are we getting a transcript of the argument?
Not so far as I'm aware.
Could the parties consider whether that would be appropriate?
I'm sure we
Very
will
much.
consider whether it would be appropriate.
Thank you.
And I take the implication to be the court would be assisted.
I would be much assisted by it personally. This is obviously a complicated and important case, and to see the argument in writing is always helpful afterwards.
Not certainly. The second part of my submission assumes that the judge was right that to answer that first question in the affirmative, and it's then concerned with the potential relevance in cases of this nature of the exception universally agreed to exist if that is the general principle, that what I would call, avoiding the Latin, true injunctions against the world may be granted on a final basis in some circumstances. So by true injunctions against the world, I mean what some of the skeletons have referred to as contramundum injunctions in the Latin, and ones which are directed to bind the world or some identified section of the world, regardless of persons who are to be subject to them being served as defendants. So that, and essentially...
It's not particularly crisply expressed, is it? The question you're addressing is whether it is appropriate to grant an injunction against the world in the circumstances of this case?
More accurately,
Yes.
I am addressing the appeal against the judge's conclusion that it could never be appropriate to grant such an injunction in cases of this nature, what he called traveller injunction cases.
Right.
Of
So
course.
I've written it down, Mr. Giffin, as was the judge right that it could never be appropriate to grant an injunction against the world in a traveller case?
Yes. Well, given the time constraints, I'm obviously not going to repeat all the submissions in our main and supplemental skeletons.
That would be
Those
very
submissions
unwise.
are maintained. Okay.
That would be very unwise, Mr. Giffin.
Yes, I indeed. So, and the first part of my submissions, I want to focus upon the judge's judgment and the critical section of it in order to bring out the points which we have made in the skeletons. And the topic covered by these submissions is that which Mr. Justice Nicklin tackled at paragraphs 149 to 189 of his judgment. And that's the section starting at page 69 of the first volume of documents. May I indicate that I don't anticipate going anywhere other than Volume A of the authorities and Volume 1 of the documents, unless in answer to some question that arises. So that's where the section starts, and in particular, after setting out the submissions made to him, at paragraph 161, at page 74 onwards, and going on to page 82, the judge set out his conclusions. And what I'm going to seek to do is try to point to the key steps in the judge's reasoning, certain of which I then seek to refute. And the starting point, the first sentence of paragraph 161, the court undoubtedly has the power to grant an injunction that binds non-parties to proceedings. So the argument we have here is not an argument about jurisdiction in the strict proper sense of that term, i.e. whether the court has power to grant final injunctions that bind later newcomers. The judge has concluded it does have that power, and no one is disputing that. Rather, the issue is whether there is an objection of principle to the court's power being exercised in the way that's in debate. And well, I'll come back to some of what follows, but the next key paragraph in my submission is paragraph 167 on page 76. If I take the first two sentences, it's now well established that the court can grant an interim injunction against persons unknown. I should be emphasising the word interim. The court can grant an interim injunction against persons unknown, which will bind all of those who fall within the description of the persons unknown in the interim injunction order. That may include people who only fall within the definition of persons unknown as a result of doing some act after the grant of the interim injunction. So the judge there accepts two propositions so far as interim injunctions are concerned. First, that it is possible to become a person unknown as identified in an injunction by virtue of doing some act, and that the same act may likewise make the person who does it into a party to the proceeding. So persons unknown are not non-parties in this context.
That's what Lord Clark said in Gamma, right?
Yes.
And how does that work? How does it work?
In practice?
No, I mean, how does a person become a party to proceedings by doing something? I mean, I'm just interested.
Well, essentially, because by two mechanisms in the form of order, two cumulative mechanisms. The first is that the order will identify those to whom it is directed, typically by listing persons unknown as one or more categories of defendants and describing the particular set of persons unknown. And we'll see examples in some of the cases, but it might be, for example, persons unknown who enter onto a certain site and set up an encampment there, for instance. So that's the first limb, as it were. Then secondly, the order or some order made in the proceedings will provide for a form of alternative service
How can that happen after a final injunction?
How can it happen?
Is that what's that is part of a final injunction? Is it?
Yes,
Okay.
yes. And my lord,
So they become a party. I mean, the answer to my question simply is they become a party when they're served
yes,
with the process envisaged by the final order.
Lord, precisely.
Yeah.
And if one is looking at traveller, these encampment injunction cases, typically the service will be effective, will be treated as effective by going onto the land, and one of the means, one of the requirements upon the claimant will be to post copies of the injunction and other related documents at the entrances to the land.
So having become a party in the way that you have described, the person on the land is then able to challenge the merits of the order, not just against that person, but generally?
Well,
I mean, normally you serve people so that they can fight the case.
yes, absolutely. Yes. I think, well,
I mean, is the answer to that is that the order itself can provide for such a person to make application to vary or discharge the order?
yes.
I mean, is that right, or I'm just suggesting it?
It can provide for that, it should provide for that, and what the judge has effectively held on issue 1, what he called issue 1 in the case, on which all the appellants except Ms Bolton support his conclusion, is that even if the order doesn't say that expressly, it is implicit that such an application may be made, or that it follows from the provisions of the CPR that it may be made.
And where's that in his judgment?
Right. I think para 146 on page 69 is probably the best single paragraph for that. But the section is 135 through to 148.
Yeah.
So, to answer then Lord Justice Lindblom's question,
I think it's Lord Justice Lewison.
I'm so sorry. I didn't know. The last time I appeared in front of my Lord Justice Lindblom was sitting alongside him. The liberty or the right is there in order for the party in question to say, I should not be subject to this injunction. What they are entitled to do is to come and say that to the court. However, if the basis on which such a person persuaded the court that the injunction should not apply to them was such as to demonstrate that the injunction should not have been granted at all, or should not have been granted in that form at all, then it would follow that the court should discharge or vary it generally. And as was just seen from the paragraph, the judge held, and again we support, that the court does have jurisdiction to act of its own motion, if that's the right phrase in that scenario. And indeed, it is trying to encapsulate our case at its shortest, we submit that there are no inexorable conceptual objections to the grant of final injunctions against newcomers, persons unknown, yet to be identified. The key principle is one of procedural fairness. That is or ought to be the governing principle. And if one can find ways of granting such an injunction in a manner that is consistent with the requirements of procedural fairness, then there is no objection in principle to do so. Of course, obviously, it has to be examined whether it's appropriate on the facts of a particular case, but that's not the issue with which this appeal is concerned. Clearly, if the person who only, as it were, comes to the proceedings is the newcomer after the final order is made, if they could not ask the court to change or discharge the injunction, that would be an obviously very great problem in terms of procedural fairness.
So that is really, Mr. Gibbon, your critical submission.
Yes.
Would that be right?
Yes,
and
it is.
You need to persuade us that that submission is consistent with the authorities.
Yes, yes. And if I can just indicate, I'm going to try and deal with some of the points in the judgment that might be said to be more conceptual objections, and I'm going to look at some of the case law. My learned friend Mr. Anderson is going to deal more specifically with how procedural fairness may be achieved in these cases, and he will look at some of the other cases.
Okay, I mean, Mr. Gibbon, I don't want to query the way you've broken it down, but I do want you, all of you, to help the court.
Yes.
And then by bifurcating the submissions, it may or may not help the court. Can I just tell you what I'm concerned about so that all listening can know? I am concerned that Canada Goose and Cameron are obstacles in your path. I am concerned that Bromley is inconsistent or may be inconsistent with Canada Goose. I am concerned as to how one can distinguish Canada Goose in this case. And your submissions on those 3 points would be very valuable. Whether it's yours or Mr. Anderson's or anybody else's, I don't mind, but the submissions of the appellants on those points would be very helpful to me.
Yes.
Bearing in mind that we've only got 2.5 days for this appeal and we've read an awful lot of material already.
I'm grateful for that. Yes. What your Lordship has just referenced is more Mr. Anderson's territory in the allocation, but I'm quite prepared to say things about it as we go through.
Okay,
so.
well, you take your own course, and you'd given us 2 critical steps in the judgment. We were paragraph 167, and you're presumably going on to a 3rd critical step.
Yes, indeed. So, and if I hadn't already said it, the other thing that one sees from paragraph 167 is it's possible for a newcomer to be bound in that way, someone who does the relevant act after the grant of the interim injunction. Now, of course, we say that is right, but the parting of the ways between us and the learned judge is indicated by the first sentence of the next paragraph, paragraph 168, where he says, at the interim injunction stage, there is no conceptual difficulty with the gamble principle. And
we go to 174, don't we? That's where he deals with final injunctions.
Precisely. And so the implication is there is a conceptual difficulty at the final stage, and 174 is where the judge sets out how he sees that. And 174 is an important paragraph. The second and third sentences of it state a conclusion that the court can only make a final order as a result of adjudicating upon the merits of a claim made against the defendant who has been identified and served. And, Lord, as I suggest that in the paragraph one finds 3 points made by the judge in justification of that conclusion. The first is the sentence that begins about halfway down. It is fundamental to our process of civil litigation that the court cannot grant a final order against someone who is not party to the claim. But as paragraph 167 has demonstrated, it is possible for newcomers to become party to the claim. It is simply that happens after the relevant order has been made. And what we submit is that if an order that takes effect against a person whose status as a party postdates the order is conceptually acceptable and possible at the interim stage, then, as paragraph 167 shows it is, then there is logically no conceptual difficulty at the final stage. And picking up the answer I just gave to my Lord the Master of the Rolls just now, what is fundamental, we submit, to our process of civil litigation is that it should be conducted in a manner which is procedurally fair. Although that's primarily in Mr. Anderson's bit, may I make 3 brief points about it at this stage?
Well, I mean, just you can, of course, but you were going to make 3 points. You were going to tell us what 3 points supposedly justified.
Yes.
Paragraph 174 of the judgment. And do you want to complete those 3 points before you give us 3 points on procedural fairness?
Yes. Let me identify the judge's 3 justifications.
It would help me if you did.
Thank you. So, so the next of the judge's justifications in paragraph 174 is or the next one I'm going to deal with, is the citation from Canada Goose, that sentence that is set out at the end of the paragraph. The trial is between the parties to the proceedings. Once the trial has taken place and the rights of the parties have been determined, the litigation is at an end. And what I'm going to submit in a moment, in light of the judge's correct answer to issue 1, that is not a correct, or at any rate a complete statement of the position.
Well, you say it's not true, really, because in this kind of order, there is no magic in the distinction between a final and an interim order, and these, quote, final orders are in some senses still interim.
Or they are certainly not final in the sense of being...
Well, we shouldn't be hidebound by some procedural nicety of distinction, because they envisage continuing applications to the court, whether they're final or not.
Yes.
Yeah, okay.
Yes, absolutely.
And the third point
and the third point is, just going back into the paragraph, the sentence that begins, a court cannot at a trial, so that's about half a dozen lines up from the quote, a court cannot at a trial adjudicate whether a claimant has established an entitlement to a remedy against a defendant unless it is possible to identify who that defendant is and whether the claimant has demonstrated by evidence that he or she has committed some act that entitles the claimant to relief. And
how does that work in what you might call a plain vanilla squatter's case? You start your proceedings under Part 55. You serve by affixing the process to the land, and let's suppose there are 10 people on the land at the time you serve. By the time you come to execute the order, there are another 6. The enforcement officer will simply enforce the order against whoever he finds on the land.
Yes, that very point is discussed by the Supreme Court in the case of Meyer, which we have in the bundle, and the position is, as your lordship indicates, as I understand it, but the possession order as such does not, the possession order does not have effects save against those in possession when the order is made.
Yes, but it has effect against those in possession at the time when it's executed, whether or not they've been made parties to the action.
Yes, the act of execution, because the execution will entail the bailiff being directed to restore possession of the land to the claimant. Yes. So there is, according to the Supreme Court in Meyer, a distinction between, in possession proceedings, between the order and the process of execution. That third justification from the judge, again, just as the headline, we submit, does not stand with the nature of I'm sorry, I don't know a good Anglo-Saxon substitute for quietinate. I will try and
Precautionary.
precautionary. Does not stand with the nature of precautionary injunctive relief. So those are the 3 points in the paragraph. Let me now try and deal with them. I said I was going to make 3 short points on the procedural fairness, natural justice issue. The first is that I would invite the court to bear in mind that at paragraph 117 of his own judgment, page 62, the learned judge drew attention to the Wolverhampton injunction, which, although finding it not easy to categorise, he ultimately decided was a final injunction. He noted, and that injunction, which Mr. Anderson will no doubt take you to, is carefully drafted, it provided for extensive publicity, and it had a built-in requirement for review of specified future dates. And Mr. Justice Nicklin acknowledged that avoided, as he put it, many of the pitfalls and difficulties. So it is possible. Secondly, we, in the sense of the legal system, accept, I submit, on a daily basis that people are impacted by court orders, and especially by injunctions, which have been made without an opportunity at the time of making the order for them to make submissions. And that is true, for example, of injunctions granted without notice. It's true of injunctions granted prior to the issue of proceedings. It's true of interim injunctions binding newcomer persons unknown, which we've seen It's true, for example, of injunctions granted against representative defendants, so far as the class represented is concerned. And it's true of injunctions which operate to restrict the freedom of action of third parties who are not parties to the proceedings, for example, in the spy-catcher scenario, and indeed in the case of many freezing orders, for instance. In all these cases, in my submission, the law acknowledges that difficulties and risks exist, but it considers that on appropriate facts, the need for effective injunctive relief makes it sufficient that procedural fairness is achieved by allowing the party affected to come to the court after the order has been made. And we say that there is no difference in kind if one is talking about a final injunction which expressly or by implication has the liberty to apply. It may be that there is a difference of degree and that it is appropriate for the court to exercise particular caution at that stage, but there is no conceptual difference in terms of procedural fairness. And my third point on natural justice and procedural fairness is that it is axiomatic that one cannot commit a contempt of court by breaching an injunction until one knows about the injunction. And in a person's unknown case, a newcomer case, you won't be bound by the injunction until you do some act, which is usually, certainly in these type of cases, precisely what would result in you being served and having that knowledge. So we are not talking here about people finding themselves in contempt of court as a result of injunctions about which they knew nothing. Now, well, the second of the justifications was the point about being litigation being at an end, and Lord Master of the Rolls has indicated correctly that we say that's simply not right. The litigation is not in the material respect at an end because such a newcomer is entitled to come to the court within that litigation. And then that leaves the suggestion in paragraph 107.
As the judge acknowledged.
As the judge acknowledged.
At 164.
Yes. Not merely acknowledged, but positively held in the face of contrary arguments from his fault. And if we then look at the sentence that says that a court cannot at trial adjudicate whether a claimant has established entitlement to a remedy, etc.
Where are we?
This is still para 174, page 77. It's that sentence that begins, a court cannot at a trial.
Mm-hmm.
I perhaps read with the preceding sentence. My lords, it is right, of course, that a claimant must demonstrate an entitlement to any relief or remedy that is sought. But it is with respect a non sequitur to say that a claimant must demonstrate that the defendant has done some act entitling the claimant to relief. The court can, for example, grant freezing relief as part of a final order, and that may be against third parties altogether. And importantly, in the present context, there is, in my submission, no doubt that it is possible to grant a final precautionary injunction. And the whole point of precautionary injunctive relief, of course, is that the defendant has not yet done anything wrongful, at any rate, if the injunction is of the purely precautionary kind. Rather, its grant is based upon evidence showing a strong apprehension of future wrongdoing.
Well, we always used to say threatening and intending.
Yes.
The defendant is threatening and intending to commit a nuisance. The defendant is threatening and intending to do all sorts of things, and we grant precautionary injunction.
Yes.
Every day of the week.
Yes. Yes, indeed. And taking that then to the next stage, there is, in my submission, no reason of logic why that sort of apprehension can only exist in relation to an already identified defendant. And Lord, we say that the same error of logic is with respect apparent at paragraph 197 of the judgment. That's on page 84. And and at the foot of the page, the judge says, outside the area of persons unknown injunctions, the inadequacy of proof of historic wrongdoing by A as a justification for a precautionary injunction against B would be immediately apparent. And reading the paragraph as a whole, my understanding is that the learned judge was saying it's inadequate in a persons unknown case as well. It's just that it may not be so immediately obvious that that's true. But, Lords, we've sought to address that paragraph and that proposition at paragraph 39 of our main skeleton argument, which is at page...
Paragraph 39.
Yes, it's internal page 13 and bundle page 23 if you're looking at in the bundle.
This is the skeletons bundle.
No, yes.
33.
And
this is 39 in your skeleton. The judge expressed the view, is that?
That's the one.
And that's nowhere near page 33. That's page 23.
Yes. What we say is that there is no logical basis for that proposition. The material upon which the court is invited to act when granting an injunction will necessarily relate to what has been said and done in the past. But inferences can be drawn from such material about what is likely to happen in the future in the absence of an injunction, and that's the whole basis of precautionary claims. Naturally, a court must be appropriately cautious in drawing such inferences in what relief should be granted on the basis of them. And this, we say, was with respect clearly explaining relevant guidance given in the Ineos case, and Quadrilla essentially follows in Ineos with minor modifications. But the fact that evidence relates to the past behaviour of A does not mean that it is incapable of founding an inference about the likely future behaviour of B. Rather, that goes to the weight which should be placed upon the evidence in that respect. And we submit that it is more realistic or typical in the present context to ask whether evidence about the past conduct of a substantial number of persons, significant numbers of whom it has not been possible to identify, is capable of founding inferences as to the likely future behaviour of persons who have not yet been identified. And we submit that in appropriate circumstances, the answer to that question is clearly yes. And this is this is in effect the rolling cast practical problem. the problem of people who are unknown, unidentifiable at the point at which the final injunction is granted, but who, on the evidence, are likely to carry on what the identified defendants, if any, have been doing. Now, this is a case, these are appeals about traveller injunctions, and some of the evidence shows how in some scenarios there is the problem of in my client's evidence, the site is left by one group, another group comes straight on, the first group goes straight off to another site. But it's also a problem that is obviously capable of arising in protest cases where others will wish to support the cause, if I can put it that way. It's a problem that might arise, for example, in certain kinds of copyright infringement or the passing off type cases where one company is set up to market the fake watches or whatever it is, and then as soon as that company's been closed down, another company pops up and so on. It might arise in cases where there is actually no connection between the defendants as such. For example, in the bundles, your lordships have the injunction that's in force at the Shard, where apparently people like to climb the Shard from the outside from time to time. One doesn't know in advance who they're going to be, and it's a bit late to get the injunction by the time.
And there is such an injunction, is there?
My Lord, there is. We have referenced some of the examples in, I think it's note 2 of the skeleton. Yes, footnote 2 on internal page 5, bundle page 15, skeleton, and your lordships have the references, and I think I'm right in saying that the Shard case is the one called King Thompson. The actual judgment there is a committal application, if I remember rightly, but we have also included in the bundle the final injunction currently in force, and we've put it under the heading of urban exploring.
So it's the Canary Wharf. Oh, it's King Thompson.
I think it's King Thompson.
So what is what's the other one about Canary Wharf? Oh, that's all King Thompson.
Canary Wharf, I think, is another climbing case. I would just have to ask for someone to look that up for me. The Chelsea case is about people climbing on the roof of the stand and taking photos to post to social media, which is apparently another facet of the urbex phenomenon.
So when we say BC, we mean bundle C, do we?
Bundle B, tab C, and or section C. It's been put into section.
Is that authorities bundle?
Authorities bundle B, and section C is the case law section, as opposed to legislation and textbooks. And so that if the court wishes to look at that, it's tab 15 within that section C, which is page 2019, judgment in committal proceedings which sets out some of the history and the justification, and the final the interim injunction is the one that appears at page 2032, and the final injunction, which appears from the Shard's website, is currently in force, is at 2035, and if so, that is purely a persons unknown injunction. The defendants are described as personal persons unknown, entering in or remaining at the Shard or Shard Place, including in the airspace immediately around the Shard or Shard Place, without the claimant's licence or consent. And the injunction, paras 1 and 2, is against entering certain areas of the Shard, which are presumably those where unauthorised persons would go. And
did Mr. Justice Murray mention Canada Goose?
Well, it was a committal application, so he may well can't immediately see that he did. The injunction for the purposes of committal proceedings would obviously have been taken I can't see a mention of
But if the judge is right, that injunction was unlawful.
well, that seems inexorably to follow.
Okay.
And we rely obviously on the case not as an authority on the point it's dealt with, but it may be helpful for the court to have in mind some of the contexts in which the phenomenon of the rolling class of wrongdoers is a real...
I mean, your submission, to put it in a nutshell, Mr. Giffin, is that this judgment is completely unworkable. Is that right?
It will make certain kinds of injunctions unworkable, yes. And injunctions
and very
which
impractical.
address real practical
And very impractical.
Yes, yes. Absolutely.
And has wide ramifications.
All those things, yes. Again, Mr. Anderson knows more about this particular one than I do, having been involved in it. But there is an issue of car cruising in the Black Country. I expect car cruising, probably knows, people turn up in the early hours of the morning at a particular site on the public highway and race cars against each other in a way maybe rather dangerous for anyone who happens to be around at the time. You may be able to identify some organisers, but ideally, an authority seeking an injunction against that activity would wish to say that no one is to engage in it, including any of the rolling cast of participants whom it hasn't yet identified.
So car cruising is a bit of a euphemism.
Yes.
Yes, I think I've understood rightly what car cruising is.
It is racing, is it?
Is that
It's
right?
not just racing. It involves having a car that you want to show off and doing all the things that one does with such cars. So sometimes racing, sometimes parading very slowly, causing traffic jams, sometimes taunting policemen. It's a wide-ranging activity, and it's very difficult to know who is committing it.
And you're an expert, Mr. Anderson.
Well, we have an injunction against it, where I live, so I can't, I'm afraid.
Yet. Yes, I've dealt with I've dealt with the justifications set out in paragraph 174. I'm now going to go to 3 further points in the judgment before I turn to some authorities. And the first of those points is paragraph 183 on page 79. Where he in effect holds, building on the conceptual points already made, that the adversarial nature of civil proceedings makes it intrinsically unsatisfactory to grant relief against persons unknown, including newcomers. And in support of that, the learned judge cites a passage from the Bromley case. Now, I'm going to leave Bromley mainly to Mr. Anderson, but it is worth noting at this stage that from the citation, what conclusion Lord Justice Coulson in Bromley actually drew from the need to pay proper attention to procedural fairness, and that's the cited paragraph 34, in the middle of page 80. The principle that the court should hear both sides of the argument is therefore an elementary rule of procedural fairness.
I'm sorry, I'm a bit behind. Is it where are you in the judgment?
I'm in the judgment at paragraph 183, which starts at the foot of page 79.
Yes.
And in the latter part of that paragraph, the judge cites 4 paragraphs from Bromley.
Oh, I see.
And
The
one I'm after is
31 to
paragraph
34 is from Bromley.
So just before we get to 184 of Mr. Justice
Yep,
Nicklin.
got it, thank you.
The principle that the court should hear both sides of the argument is therefore an elementary rule of procedural fairness. This has the consequence that a court should always be cautious when considering granting injunctions against persons unknown, particularly on a final basis, in circumstances where they are not there to put their side of the case. And the point is perhaps obvious, and you know, from earlier comments that Lord the Master of the Rolls has it in mind, but the conclusion drawn was explicitly not that one should not grant such injunctions on a final basis. It was that the court should be cautious, particularly cautious in doing so.
I mean, it's strange, isn't it? Because Lord Justice Coulson was in the court in Canada Goose and said nothing about Bromley at all. It wasn't even cited. But he delivered the judgment 2 months before.
Yes, I think what's being said, and I think this is right, is it's not cited in the referred to in the judgment, but it was cited to the court.
Right, okay. But
My Lord, I can confirm that I was counsel for the appellant to Canada Goose. It
it's
was
not
cited.
recorded as doing so in the report.
It wasn't. It was submitted. The reason being that the skeleton arguments were
Take your
filed.
mask off, Mr. Bowes, if you don't mind.
The skeleton arguments were filed before Bromley and I think Quadrilla were decided, and there were then supplemental skeleton arguments both by us and the advocate to the court, and therefore it was clearly cited.
Okay.
Yeah, I think I'm right in saying the time lag between the judgments is not even months. I think it's a few weeks. They certainly followed very hard on each other's heels.
Yes.
And but the point is obvious.
So we're at 34, we're at 183 in the last citation.
Yes, indeed. So that was the first one of the 3 other points I wanted to make about the judging. The second is this, and it concerns the implications of what the judge has held about the granting of final injunctions for what is then a proper exercise of the court's power in relation to interim injunctions. That, I'm afraid, is a convoluted formulation, but the point I'm trying to make is that the learned judge has indeed carried the logic of his conclusion about final injunctions through to what he says about the proper use of interim injunctions in persons unknown cases. And what he says, I will seek to make good in a moment, is radically inconsistent with the way that such matters have been approached in the existing case law. So we need to look at paragraph 155 by way of introduction on page 72.
And we have to have convoy collateral in mind.
I'm sorry, more than a
We have to have convoy collateral in mind. You don't need an injunction according to the Privy Council. You don't need a cause of action in order to get an injunction.
Well, yes, I've been calling it broad idea, but yes, convoy collateral, yes. Yes. And although this refers to a submission by me, it's based upon what Mr. Justice Nicklin had said a short time previously in Enfield, which is another related case. In another part of the judgment, he called it a conundrum. And he says, paragraph 41 of Enfield, the difficulty is this. Even if I were to grant an interim injunction in terms that were proportionate and targeted at the type of fly tipping I have described, it was a case about encampment and fly tipping, there would be no real prospect of serving the injunction matter. No one is presently occupying any of the land and carrying out fly tipping. The claimant seeks orders for alternative service of the claim form in any injunction. But even assuming that such orders were made, the court would shortly thereafter move to consider what final relief should be granted. And the learned judge makes the points, first of all, that in a case of this kind, you'd expect the final hearing to come on pretty quickly, and it would be surprising if by then you'd actually identified any fly tippers. And then at 43 of the citation from Enfield, he says, well, I'll pick up the last sentence of paragraph 42. The consequence is that the hypothetical fly tipper who turned up at any of the 96 sites, in respect of which the court had made the final order, would not actually be restrained by the injunction. He or she is not bound as an original defendant to the claim. She's not bound as a newcomer. That's assuming the judge's interpretation of Canada Goose. The result would be most unsatisfactory. Barring some unusual development in the case, any interim injunction the court granted would be more effective and more extensive in its terms than any final order the court could grant. As there is unlikely to be much by way of development between the grant of the interim and final order in this case, this raises the question as to whether the court ought to grant any interim relief at all. This arises because, unlike Canada Goose, at the date of grant of any interim injunction, no people exist in the category of persons unknown. In terms of practical reality, the only way that the London Borough of Enfield could achieve what it seeks to do is to have a rolling programme of applications for interim orders. As soon as a final order was granted, it would become worthless against newcomers. To continue effective injunctive relief, the council would have to commence fresh proceedings and seek a new interim order. That would be litigation without end. It presents a real challenge to the conventional understanding of adversarial civil litigation as it is conducted in this jurisdiction. So, well, unsurprisingly, we took that up and said this demonstrates that this rigid distinction between interim and final orders in this context is a false one, which leads to very undesirable consequences. But the judge ultimately did not find that to be a problem. At paragraph 186 on page 81, he says, I reject Mr. Giffin's arguments based on absurdity or perverse incentives. The concerns I expressed in the extemporary judgment in Enfield do not, with the benefit of further consideration and on proper analysis, actually arise. Application of the Canada Goose principles will not lead to or permit a rolling programme of interim injunctions. And then what paragraphs subparagraphs 1 and 2 are saying is that you shouldn't grant the interim injunction unless you're satisfied that the persons unknown will be capable of being served. That is indeed what Canada Goose paragraph 82 subparagraph 1 says, but in our submission, known sequitur that service has to occur prior to the making of the final order. And then sub 3, third, an interim injunction will only be granted against persons unknown if there's sufficiently real and imminent risk of a tort being committed to justify precautionary relief. And then just skipping a couple of lines, if the evidence does disclose a real and imminent threat of a tort being committed to justify a precautionary interim injunction against persons unknown, the claimant will then have the period between then and the final hearing to identify the persons unknown defendants. Any final order, if granted, will bind only those identified parties as defendants. So, as we read it, what the learned judge is effectively saying there is that if you grant an interim persons unknown injunction, which will extend to newcomers, that can only properly be for the very finite purpose of identifying those people sufficiently to serve them by the time the application comes on as an application for a final injunction. And so it is a very, so not only is the judge ruled this form of order out as a matter of final relief, he has very considerably truncated its proper use as a matter of interim relief. And well, that is indeed the logic of his conclusions. And were that logic not carried through, it would lead to the very consequences the learned judge identified in the Enfield.
It's completely inconsistent with Bromley.
Lord, and Ineos, I may say so. Yes. And probably Meyer as well.
Well, Meyer's very important if it's inconsistent with Meyer, because that's the Supreme Court.
Yes.
You're going to show us that.
Yes. I say inconsistent with Meyer. I would say inconsistent with some of the discussion in Meyer. The facts are. I'll show you what ships the Meyer facts. And
it also seems to be inconsistent with what he had previously said about Gemmell. On the one hand, he's saying, well, you can do all this at an interim stage. On the other, he's saying, well, you can't do it on the final stage. So it doesn't seem consistent to read back the logic of the final stage into the interim stage.
Lord, it would be consistent with Gemmell, and indeed various of the other interim injunction cases, if, but only if, in those cases, the interim injunctions had been granted on the basis that by the time of the final hearing, one ought to be able to identify the persons unknown. And what I submit is that when one looks at the relevant authorities, whether it's Bloomsbury or Hampshire Ways, or Gemmell, or Ineos, or Quadrilla, there is not the slightest sign of the court engaging in any such exercise.
And there's nothing in the practice direction that was made under 187B that suggests that the authorization to grant injunctions for planning control, which this is what it is, requires you to identify the persons unknown against whom you're making the injunction. And you could never make a fly-tipping injunction unless you actually caught somebody, an individual fly-tipping, and the whole point about preventing fly tipping is that fly tipping results of fly tipping appear in the middle of the night at unknown times, and unless you've got a policeman sat there 24/7, you can't stop it.
Rather like someone appearing halfway up the Shard or on the roof of...
Well, it's exactly the same as the Shard.
Yes, indeed it is.
So it's all pretty impracticable.
Yes, we say so. Yes.
But I mean, all these cases do not speak with one voice, do they?
Well, I know that this is coming back to what your Lordship identified to me at the outset as the critical point.
Well, because we're interested in this court, Mr. Giffen, just in case you thought differently, in precedent. And you might find it difficult to persuade me that what I'd said in Convoy Collateral about precedent was wrong. I think we are bound by previous cases in this court.
Yes.
And indeed by the Supreme Court.
Yes, indeed. But we say that Cameron is readily distinguishable, and we say that so far as Canada Goose is concerned, one should confine it to what the court actually said it was dealing with, which was protester cases. But let me not embark upon that.
Well, I mean, we do need to understand why, not why it should be confined to protester cases, because we know that the paragraph in question said so, but why protester cases are different from persons unknown cases in traveller cases. And that's what I struggle with a bit, and I need help with.
Maud, I appreciate that with respect. May I, however, just finish the
No, you carry on.
Because I think it's important to see what Mr. Justice Nicklin thought the consequences were for interim relief. And the final step in that is paragraph 248 of the judgment at page 98. And he says at the start of the paragraph, I consider that claims against persons unknown should be subject to the following safeguards. And the relevant part is his subparagraph 8 and 9. 8 is if an interim injunction is granted, and the particularly relevant part is letter D on the facing page. The court in its order should fix a date on which the court will consider the claim of injunction application further hearing. What period is allowed before the further hearing is fixed will depend on particular circumstances, but I would suggest it should not be more than 1 month from the date of the interim order, and in many cases a shorter period would be appropriate. And at the 9, at the further hearing, claimant should provide evidence of the efforts to identify the persons unknown. The court should give directions requiring the claimant, should say within a defined period, if the persons unknown have not been identified sufficiently that they fall within category 1, i.e. they're identifiable and servable, required to discharge the interim injunction against the persons unknown. So that bears out what I think the only use the judge is now prepared to contemplate for interim injunctions, this scenario, is as the stopgap whilst we're identifying people. I think, my lords, this is the point at which to go to some of the cases to try and make good some of what I have said. And the first one I'll go to is Ineos at volume A of the authorities, as these all are, tab 15, page 324. it's a case about anti-fracking protests. The claimants sought precautionary injunctions to restrain potential unlawful acts of protest before they occurred. And there were 5 defendants who were all persons unknown by description, different activities, and 2 named defendants. And your lordships will see from para 17 at the foot of page 327 that the first ground of appeal was whether the judge was correct to grant injunctions against persons unknown. And
This was interim.
Well, it was interim, but one of the points I wanted to make is you have to work quite hard in my submission to find out it was interim. There is... yes.
It's also precautionary, I think.
It's certainly precautionary. Yes, indeed. You can see it was an interim order because you can pick up the word interim from the second line of paragraph 14. But in all the remaining discussion, unless I've missed something will no doubt be correct, there is no indication anywhere in the analysis of these kind of injunctions that if the distinction between interim and final injunctions matters. There is no suggestion anywhere that at the interim stage the court is only properly concerned with that sort of exercise I've just shown you in Mr. Justice Nicklin's judgment, stopgap while you identify people. And indeed it goes slightly further because one of because this was a convention rights, freedom of expression, freedom of assembly case, section 12(3) of the Human Rights Act was in place, which requires the court to assess whether the claimants would be likely to obtain the relief sought at trial. And there's discussion about that, and that indeed actually is the basis on which the appeal was to a limited extent allowed, because the learned judge below hadn't got that quite right. But it's worth just taking a step back from section 12(3). If that required, as it did, the court to think about whether a final order, final injunction would be obtained at trial, if the judge's interpretation of Cameron and Canagous was right, then unless the plaintiff or the claimant was in a position to say, we will have identified some breakers of the injunction by the time of the final injunction, the interim injunction couldn't have been granted because one wouldn't have been able to be satisfied that that would be the position at trial. And indeed the paradox is even, in a sense, greater or more intractable than that, because as Lord Bingham said in the South Buckinghamshire and Porter case that cited in various of these, the court does not work on the assumption that its orders will be breached. It works on the assumption that its orders will be obeyed. So if a claimant comes to the court asking for an interim injunction to be granted, and at that point it has no identifiable defendants, just persons unknown, if the interim injunction is granted and is complied with, there will be no identifiable defendants by the time of the final injunction. That follows as a matter of logic. No one will have breached it so as to be served. And therefore, inevitably, the final injunction will not be granted. And therefore, Section 12.3, at any rate in a human rights case, tells you can't grant the interim injunction either. So it just becomes circular and self-defeating. But nowhere in INEOS is there any suggestion that these are issues that need to be considered at all. Now, it's true, of course, that INEOS precedes Canada Goose, but it comes after Cameron, and indeed the principal argument of counsel for the named defendant, who was in effect, who was also arguing that the injunction should be discharged against persons unknown, was precisely based on Cameron. You can see that from paragraph 26, at the foot of page 329. But they are rejected. That argument is rejected at paragraph 29. This is Lord Justice Longmore's judgment, I think, with which the other members of the court agree. In my judgment, it's too absolutist to say a claimant can never sue persons unknown unless they're identified at the time the claim form is issued. And Cameron is dealt with in the middle of the paragraph. The supposedly absolute prohibition on suing unidentified persons is already being departed from. Lord Sumption's two categories, as Cameron apply to persons who do exist, some of whom are identifiable and some of whom are not. But he was not considering persons who do not exist at all and will only come into existence in the future. I do not consider that he was intending to say anything about suing such persons. So the conclusion of the Court of Appeal in this case, in INEOS, is that Cameron is simply not about these issues. And whilst it doesn't, this authority obviously doesn't deal with Canada Goose.
Are you saying Canada Goose is per incuriam INEOS?
Yes.
I'm sorry, I used Latin.
Because it treats Cameron as dictating the conclusion reached in Canada Goose, which is inconsistent with INEOS.
So, do you ultimately get to the point of saying that there are inconsistent decisions of this court which we can choose between? I don't think you say that in your skeleton argument, but is that where your submissions are actually leading?
Well, it may be. I would prefer, although it may not make much difference in the end, to say that this is the kind of case Lord Justice Leggett, as he then was talking about in Young Salmon Parole Board, his discussion of ratio deciding.
Well, you want to keep Canada Goose in a box marked protesters?
I do, and I put it, at least at this level, and I put it that way because I recognise what was said, albeit about protesters, in quite firm and clear terms in Canada Goose. And I also recognise that although the case could have been decided without saying anything about that at all, the result of the claim being the same, I recognise that the case all shows that if you have more than one reason for a decision, they are both, or all in principle, equally ratio. But what Lord Justice Leggett says, and we respectfully adopt, is that where it is possible to read a case as authority for a somewhat narrower proposition than what the language used might imply, whether to read it in that narrow way is a matter is a nuanced judgment depending on consideration of a number of factors as set out in Youngstown. And those include, obviously, the extent to which relevant authority was cited, the extent to which what the court said on the point was essential to the outcome.
I mean, Youngstown is a Lord Legate's judgment in Youngstown is a concurring judgment with which the other members of the court didn't agree.
I think Lord Justice Haddon Cave said he thought it was better not to go into that.
He didn't agree with it, and he didn't say anything about it, and Lady Justice Nicola Davis doesn't mention it, does she?
I believe your lordship is right. I'm sorry if I've got...
I mean, Youngstown is all very interesting, and maybe all of a piece with what Lord Legate thinks, but it's not binding on us.
It's not binding on you.
No.
That's certain.
It's a comment.
It's a comment.
But I think, Mr. Giffin, you really can't say that Canada Goose was decided in ignorance of Ineos because it's mentioned in the judgments.
I can't say it is decided in ignorance of Ineos because of the reason your lordship gives, but in the section of Canada Goose that addresses this this issue, well, again, Ineos is mentioned at paragraph 90, just above the foot of the page, but it is treated simply as a case that shows that Vastint is not an answer for the claimant. There is no, with respect that I can see, no indication of the Court of Appeal in Canada Goose having engaged with what is said in the aspects of Ineos that I've just mentioned, including what it says about Cameron.
Well, picking up what my Lord the Master of the Rolls said about precedents, that may present you with a difficulty, because usually speaking, if this court decides A and then a subsequent division of this court explains A as having decided something different, we are bound by the explanation. Unless you get to the position in which you can say, well, there really are two conflicting positions of this court, and we can choose between them.
Yes. Well, there are two ways to potentially to deal with Canada Goose. One is to say that it is a case of conflicting decisions, in which case one is down that road. The other way of looking at it, dealing with it, is to say Canada Goose is, indeed as it says it is, a case about protesters. And that would invite a question which I think was implicit in what my Lord the Master of the Rolls was putting to me. Why should protester cases be any different? It would be unsatisfactory, I acknowledge, to distinguish Canada Goose by confining it in a way that didn't seem to have any rational logic to it. But there are features of protester cases which are distinct from the traveller injunctions in encampment cases with which we are concerned.
I mean, when the travellers turn up on your site and say we're protesting against the lack of transit camps in your borough, are they protesters or just trespassers?
Well, it's hard to say, and that's not how I suggest one should approach it. The point about what one would normally label as protester cases, some protester cases, is that they concern acts which are not intrinsically unlawful, but which become so if they are, or activities, if they are carried on in a certain way. So, for example, protesting on the public highway, which is what Canada Goose was concerned with, is not intrinsically unlawful. But if it is conducted in a certain way, it may become so.
What way?
Well,
How does it become unlawful?
well, the law of public nuisance hinges critically upon reasonableness of user of the harm, if it's a highway case,
And that was.
I beg your pardon?
It was. Canada Goose was an unreasonable user of the public highway case.
Well, that was the allegation. Yes, certainly. Yes, and
Hampshire Waste, on the other hand, was entry onto private land. So you would say that that's not a protester case, even though the whole thing was a global day of action against incinerators. That's not a protester case.
I do say one should distinguish trespass cases or cases where there is a similarly.
So whatever the motivation for the trespass doesn't matter. It's the trespass on private property that matters.
It's the nature of the act. Yes. Yes.
And when we're considering convention rights, there are A1, P1 rights to consider in trespass cases and not in protester on the public highway cases, at least as a balance to Article 8.
Yes. It might be difficult to say there was never any A1, P1 angle in public highway trespass case. It's certainly not core in the way that that it will be in a trespass case. And after all, the very concept of what's a reasonable or unreasonable use of a public highway must factor in, one assumes, rights of freedom of assembly and freedom of expression. So where that goes to, in terms of why is it different, one can see why it could be said, sensibly, that if the nature of the wrongdoing is simply public protest, it is not possible at the final stage, and therefore more definitively than may be required at an interim stage, to formulate in a manner suitable for an injunction what it is that is being restrained. Now, one could, of course, debate whether that shouldn't simply go to how you exercise the jurisdiction on the facts, but it does, at least in my submission, provide a coherent basis for saying that there is something particular about what might be called protester cases.
But I mean, the problem is that precautionary injunctions don't require any trespass to have taken place.
They don't, but you have to apprehend with sufficient probability the trespass.
So it's what you apprehend.
Yes.
Whereas here, in protester cases, you're only apprehending going on the public highway in a way that becomes a nuisance.
Well, yes.
Or might become a nuisance.
Might become a nuisance.
Or
Well, that
might
might, yes.
become a nuisance,
Indeed.
depending on an exercise of judgment about whether it's reasonable or not.
Indeed, indeed.
It's quite a fine distinction.
It is, but the alternative is to try and find some more satisfactory way of explaining why Lord Justice Coulson didn't say anything about Bromley, where he
Well,
said...
why do you say Lord Justice Coulson? I thought it was the Master of the Rolls.
Oh, in Canada Goose?
Yeah.
Oh, I hope it was.
I think it was a judgment of the court.
But why do I think it's actually...
If you look at page 394 in the authorities bundle, it says the Master of Rolls, Lord Justice Richardson Coulson, delivered the following judgment to the court.
I'm so sorry. I don't know what I have been saying. Well, that's simply an error on my part. I do. I've been saying that throughout and in my skeleton.
And if we were attempting to divine who wrote what, it seems to have the Master of the Rolls' style about it.
So be it. So, well, Lord, I do apologise if I got that wrong. Right. But the point remains, Bromley was, as Mr. Bates tells you, cited. One of the members of the court had delivered the judgment in Bromley only a very short time previously.
I mean, it is remarkable that Bromley is not mentioned either as a case cited in argument or as, or maybe I'm wrong. Hang on. No, not mentioned.
I think the position is, as Mr. Bowes said, it hasn't found its way into the law report as a case cited, and that may be because the law report is looking at the original skeletons.
Well, it may be, but I mean, it's interesting that it says the following additional cases were cited in argument, in other words, when counsel stood on their feet, and the additional cases were not cited, were referred to in the skeleton arguments. So, well, either way, it's inaccurate.
Lord, I can't tell.
I mean, it's all very well when we're so close to it, and we can find out, and we've got Mr. Bowes with us to give evidence. But if we were looking at this in 10 years' time or 20 years' time, we'd probably have none of that.
Yes. Now, of course, I can't submit to you that it's per curiam because of Bromley, because what's said in Bromley about caution when granting final persons unknown judgment manifestly no part of the ratio. But it is a very, if one were to treat Canada Goose as laying down a absolute and general proposition, it would be a very striking discrepancy. It would be a fair description.
Well, it would neuter the jurisdiction.
Yes.
Does it mention 187B?
Canada Goose.
Hmm.
May I leave that to others to...
All right, I'll check myself.
I don't think it does because, of course, there wasn't a planning authority involved.
Yeah. Well,
But I think even in the discussion,
I don't see how it would have arisen.
it wasn't mentioned. But it was in Bromley. Anyway, I had to chase that here. Mentioned at 42 and 43.
Lord, with an eye on the clock, I should seek to... I think having shown the court Ineos, I'm not going to turn up Quadrilla, which is the pair to it, but I say that it discusses Ineos, it modifies it in one slight respect, not direct material, which is that whether Quadrilla is more amenable to final injunctions, to interim injunctions restraining action which may be lawful as part of giving certainty to an order. But again, there is no suggestion anywhere in the discussion in Quadrilla that the interim final distinction is crucial. There is no suggestion that this is a holding operation until one can identify the persons unknown. And so far from being short-term measure, the interim injunction in Quadrilla was granted for up to 2 years.
And Quadrilla was after Canada Goose? No.
Quadrilla was before.
It's January the 23rd, 2020. And Canada Goose was March the 5th, 2020.
Yeah, it was before because Quadrilla gets a mention in Canada Goose.
Yes.
And can Canada Goose perhaps be distinguished on the basis that it misunderstood Cameron, do you say?
Well, I do say that because the explanation, the Canada Goose treats Cameron as decisive, but the Court of Appeal in Ineos, as I have shown, had already said that Cameron was not dealing with this category of persons unknown.
Sorry, Court of Appeal in Bromley had said
No,
it was
in Ineos. It said
in Ineos.
That's the That's the passage I read you from Lord Justice Long.
Rejecting the submission that
Yes.
Cameron
Yes.
governed. Yeah, that was his paragraph 29, I think.
Yes. Okay. Similarly,
And I mean, that's a pretty critical submission, isn't it, Mr. Giffin? Because otherwise you run into the buffers, rather, unless you're right about protesters versus travellers, which does, for myself at least, seem a rather difficult distinction. I mean, you've got to get your, if I can put it this way, your screwdriver into the interim final distinction.
yes.
And the only way you can get that into it, the only way you can achieve that, it seems to me, is by saying that Canada Goose failed to follow, well, or wrongly relied upon Supreme Court authority for something it didn't say.
Yes. Well, yes, I'm prepared to accept that. I'm anxious not to trespass too much on Mr. Anderson's territory or his time, but yes, I do make that submission.
Well, I mean, you know, I'm very keen to get the submission clear as to what we have to decide, Mr.
Yes,
Giffin. I don't mind who I'm listening to, but I need to know what we have to decide.
Well, if we
I think
look at what...
I think that leads you to the conclusion, Mr. Giffin, that there are two consistent decisions of this court.
That limit of the argument does. If the court is not, as it were, prepared to adopt the, when it says protesters, it means protesters submission, yes, it does. And I think I indicated an answer to my lord that I'm prepared to make that decision.
And the two inconsistent decisions are effectively Ineos and Canada Goose, not Canada Goose and Bromley.
Yes, that, for the purposes of pairing curiam, that has to be what I say. I can't treat Bromley. So.
Because Bromley, whatever it said, was overturned.
Indeed.
Okay.
I'm just turning the pages of if one does look at the reasoning on this issue in Canada Goose, so that's Bundle A, Tab 18, paragraphs 89 to, I suppose, 93. The treatment of Cameron is really at paragraphs 91 and 92 on page 414. And the court says, this doesn't mean to say there's no scope for making persons unknown subject to final injunction. That's perfectly legitimate, provided the persons unknown are confined to those within rule assumptions category 1 in Cameron. The people who are already identifiable, albeit not by name. And then paragraph 92 is, in a sense, the key paragraph. In written submissions following the conclusion of the oral hearing, Mr. Bow submitted that if there's no power to make a final order against persons unknown, it must follow that, contrary to Ineos, there is no power to make an interim order either. And that's the inconsistency identified. We do not agree. An interim injunction is temporary relief intended to hold the position until trial. In a case like the present, the time between the interim relief and trial will enable the claimant to identify wrongdoers either by name or as anonymous persons within rule assumptions category 1, subject to any appeal the trial determines the outcome of the litigation between the parties. And then there's the bit about the trial bringing the litigation to the end, we've already seen. So, the Court of Appeal in paragraph 92 is reasoning its rejection of Mr. Bose's submission on two bases. One is Cameron and Lord Sumption's categories, but in Ineos, the Court of Appeal says Lord Sumption just isn't dealing with this issue, persons unknown injunctions. And then further, it makes the point about interim injunction being temporary relief, and you've got time between interim relief and trial to enable the claimant to identify the wrongdoers, i.e. the exercise, which is spelled out in more detail in Mr. Justice Nicklin's judgment in the present case. But as we've seen, that is not the question the court asked itself in Ineos, or for that matter in Quadrilla, or Bloomsbury, or Hampshire Ways, or, so far as I can see, in any of the cases in which, prior to Canada Goose, persons unknown injunctions were granted at the interim stage. So that's the inconsistency.
So that makes it inconsistent with a number of other Court of Appeal decisions. I mean, it would help me if you, if not you, but your side, could take the time to tell us in writing, in the course of this hearing, what precisely you say Canada Goose is inconsistent with, on the assumption that we're not prepared to accede to your submission, that it's simply to be distinguished on the ground that it's a protester case, and how it is inconsistent, and with specifically which decisions of this court, not obiter, but ratio.
Well, yes.
And I really urge a deal of care in writing that down.
That message is received.
Not least because the advocate to the court and the interveners will want to look very carefully at it.
So, again, I won't turn up Bloomsbury or Hampshire Ways, but what I will say about is, although they are clearly interim injunction cases, they are both cases where plainly the interim injunction was going to be dispositive. In interim in Bloomsbury, it was until publication date for Harry Potter. In Hampshire Waste, it was until the day of action. So, if the interim final distinction is crucial, it may be seen as rather unsatisfactory crucial distinction in cases where there is going to be a final trial. The only other case I want actually to turn up is the minor case, which is in tab 9.
Sorry, I just missed the other case, Bloomsbury and
Hampshire Waste.
Hampshire Waste. Sorry, which one do you want to turn up now?
Mine, please.
Mine.
It's tab 9, page 181.
Yep.
The Supreme Court had to deal with two issues arising out of the occupation of forestry land by a group of, I think, technical called neutrals. And the main issue on the appeal was whether you could get a possession order in respect of land which had not yet been occupied by the defendants, i.e. on a precautionary basis, and the Supreme Court held no. The other matter in the case was the injunction, which had also been granted, and the majority of the Court of Appeal had granted an injunction against named defendants and persons unknown, restraining them from occupying both the particular patch of land they were already on and neighbouring land. So that's the context. The injunction itself is set out at paragraph 3.
And what did the Supreme Court say about that? Injunction?
They upheld the grant of the injunction.
Thank you.
The injunction is set out at paragraph 3, and I need to show you that, so I need to make clear this is not in fact a case of a newcomer, an injunction binding newcomers, because it was expressed to apply to people who had been on the land between the 13th of February 2007, which is when the claim was issued, and the 3rd of August, which was the date of the first instance decision by the recorder in the county court. So perhaps because it was just dealing with a single group of people, the injunction is limited in that way, and that is why I cannot say that that there is an inconsistency with the actual outcome on the facts of mine. So having acknowledged that, may I nonetheless ask the court to look at Lord Roger's judgment, paragraphs 1 and 2, where he says, if a group of people come onto my land without my permission, I shall want the law to provide a speedy way of dealing with the situation. If they leave but come back repeatedly, depending on the evidence, I shall be able to obtain an interlocutory and final injunction against them return. But they may come onto my land and set up camp there. Again, depending on the evidence, I shall be able to obtain an injunction, interlocutory and final, against them remaining and also against them coming back again once they leave as required by the injunction. Similarly, if the evidence shows that once they leave, they're likely to move and set up camp on other land which I own, the court can grant an injunction, interlocutory and final, against them doing that. So Lord Roger treats the interlocutory and final as one and the same. Now, he then continues in paragraph 2. Of course, it is quite likely that I won't know the identities of at least some of the trespassers. If so, Mr. Justice Wilson regards an injunction as useless, since it would be wholly impracticable for the claimant to seek the committal to prison of a probably changing group, and one should emphasise those words because that seems to indicate that newcomers are in mind, of not easily identifiable travellers, including establishing services of injunction and of the application. But
and Lord Wilson was in the minority in this case, was he?
No, or certainly not. I think it's unanimous.
Was he the first instance judge?
I think this is a different decision.
Oh, different case. Yeah,
Yeah, different case.
Thank you.
I'm sorry. I which is a different.
The reference to Mr. Justice Wilson in Secretary of State and Drury is not the same case as the decision of the Court of Appeal in the Meyer case.
I think actually it is. I think Mr. Justice Wilson, although still a puny judge, was the minority judge in the Court of Appeal, and he cited Drury.
Well, he may have cited Drury, but it's not the same case because the citation for Drury is 2004 One Weekly Law Reports, and the Court of Appeal is 2009 One Weekly Law Reports, so they are different cases.
I'm sorry, I misunderstood. Your Lordship's quite right. But what Mr. Justice Wilson said was in this case in the Court of Appeal, I believe, and not in some other case.
Anyway, that was
This
an
is sort of
unduly
quite
pessimistic assessment according to Lord Roger.
Exactly, and he cites the all those cases, and I can't say this is ratio D, and they go on to grant the injunction in face of the argument that it would be futile to do so. Clearly. No, I can't say it's ratio. The Supreme Court.
So what did you say?
Clear. Although I can't say it's ratio.
Yeah, they go on to grant the injunction.
They. I'm sorry.
So you said they go on to grant the injunction, although it would be futile to do so.
Ah,
And I didn't understand.
They went on to grant the injunction or uphold it, despite the argument that it would be futile to do so. I'm sorry, Lord. That's the argument that was rejected. Yeah. But it is clear in my submission to Lord Roger's reasoning that he sees no distinction between interim and final injunctions in this context, and contemplates such injunctions being granted not only against persons unknown, but ones who are a probably changing group.
So you'll need to consider whether it is your submission that Canada Goose is inconsistent with this case as well, even if it's only dicta.
Oh, yes. Well, it is inconsistent.
It is.
It is inconsistent with the assumption that underlies those dicta. I cannot say that it is inconsistent with the ratio.
Because they didn't grant a final injunction.
Well, because the point wasn't argued as such.
It wasn't a step in their reasoning.
It was not a step in the reasoning. So I'm trying not to put it, and also because of the actual terms of the order. So I'm trying not to put it too high, but I do urge upon the court.
No, you just need to put it as you want to put it. I was going to say high enough, but you need to put it as you need to put it.
Well, what I put it this way: if the court sees a proper basis, apart from Meyer, for either distinguishing Canada Goose or treating it as per incuriam, then the approach of Lord Roger in Meyer strongly suggests that the court should follow that route. I hope it's a formulation.
Right, thank you.
Lord, I think that's as much as I should say about those issues. My lords have seen from my skeleton, supplemental skeleton, what we say about Cameron, which is that there is just a fundamental difference between a case about damages, such as Cameron was, and a case about an injunction, because an injunction is intrinsically forward-facing. We say distinction. But that's there in the skeleton. As far, I did say I was going to deal with.
So I didn't understand that submission. Can you just say it more clearly?
Yes.
There's a fundamental difference between Cameron because
Cameron is a case about damages. It was a claim for damages which was being pursued against persons unknown with a view to a parasitic claim against an insurance company. And Lord Sumption clearly holds, and it is the ratio of Cameron, that you cannot get an award of damages at trial against someone who you have not, at that point, been able to identify and serve. But an injunction, we say, by its very nature, is fundamentally different from a damages remedy.
That distinction, if I may say so, doesn't seem to be one that Lord Sumption draws. Otherwise, he would have said in relation to all the injunction cases that he discussed in paragraph 11 and so on, well, they're all irrelevant because this is a backward-looking damages case. But that's not what he says.
Well,
He discusses, amongst other things, Hampshire Waste, Ineos, Bloomsbury. He doesn't take the line that you are now urging, namely that it's all quite irrelevant.
Lord, in my respectful submission, Lord Sumption needs to discuss those cases because they were being urged upon the court as illustrating the proposition that one did not need to have a named and identified defendant in order to obtain an order from the court. And Lord Sumption's approach is to acknowledge those cases and then Lord, if one was to seek to find a single the reason Lord Sumption, there are two. The reason Lord Sumption says that one cannot rely on those cases to get what was being sought in Cameron is that it would be inconsistent with what he describes at paragraph 17, that it is a fundamental principle of justice that a person cannot be made subject to the jurisdiction of the court without having such notice of proceedings as will enable him to be heard. That's the critical point. But what one has to do is to apply that to the type of remedy that is in issue. If you are dealing with damages and the final award of damages, you have to have been heard by the time of the trial and the money judgment.
Well, yes, you say that, but Lord Sumption starts paragraph 17 by saying this is a more serious problem than the courts in their more recent decisions have recognised. And those decisions are very largely, are they not, injunction cases.
Lord, that is clearly true. We know that this court in Ineos did not regard Lord Sumption's having disapproved those cases, and in my submission it was right in that respect. What Lord Sumption, in my respectful submission, should be read as saying here is that there are...
Well, I'm only testing your submission that there's a world of difference between what you describe as a backward-looking case and a forward-looking case. I don't see that distinction in Lord Sumption's reasoning.
But equally, my Lord, I don't think one sees anywhere in Lord Sumption's reasoning the drawing of a critical distinction between interim, relief and final.
That's a different point, with respect.
Well, it is a different point, but one knows that even in this litigation, the judge accepts you can get interim. So the truth is that Lord Sumption does not set out in this judgment to explain either on the basis that I'm postulating or on the basis that Mr. Justice Nicklin judgment is founded on what the difference is. He, in effect, doesn't, well, it's not a decision on injunctions.
Well, what you need to do, I mean, I understand it's not a decision on injunctions, but what you need to do is to work out what were the critical steps in his reasoning in order to understand what was the ratio of this case. And there has to be, I'm afraid, some quite serious analysis done. You know, it's perfectly plain, if I may say so, Mr. Given, that your side have an uphill struggle here in the face of Canada Goose. And what I'm worried about, reading the hundreds of pages of submissions, is that none of you has adequately grappled with the ratio of the case you're trying to get us to depart from, and the ratio of the other cases that it either followed or did not follow, so that we can lay these cases end to end in a very important situation. Now, you may conclude this is not a matter that we can do anything about, and you may say we must follow Canada Goose and send this case on its blessed way to the Supreme Court. But if that's not the answer, then we need to know precisely why we can, in your submission, allow the appeal. But there has to be some rigorous analysis, if I may respectfully say so, of the decisions that help you
Lord, yes.
and hinder you.
Yes. Well, may I? Let us take first Cameron and secondly Canada. So far as Cameron is concerned, it is plainly not part of the ratio of Cameron that final injunctions cannot be granted against newcomers, unknown newcomers. And that is because that was not the subject matter of the case, and there is no statement in the case about such matters. One does need to look at what the ratio of Cameron was to see whether its logic would dictate that conclusion, even though the court itself does not say oh. But in my submission, the ratio of Cameron is to be found at paragraph 17, and is that in the case, type of case with which the Supreme Court was concerned, to grant the remedy sought would be inconsistent with fundamental principle of natural justice. The next step in the analysis, therefore, should be to ask if one is dealing with a final injunction against persons unknown, which will apply to newcomers, is that inconsistent with the fundamental principles of justice to which your assumption refers? If it was inconsistent, then although the ratio of Cameron would not dictate the conclusion, the logic of it would. But we say that the fundamental principles of natural justice do not dictate any such conclusion.
Well, you actually say that's what Mr. Justice Nicklin decided himself in relation to Wolverhampton at paragraph, whatever it was, 20-something.
Lord, and all those submissions I've made earlier, which I shouldn't repeat. So that's Cameron. But, and when I say there is this difference between damages and injunction affordable, that is why you can grant an injunction without running into inconsistency with fundamental natural justice principles, because the person is not bound until they know about it, and then has the opportunity to go to the court in exactly the same way as with an interim injunction. It is just, one could not sensibly conclude that natural justice was complied with in the interim scenario, but not the final scenario. So that's Cameron. So far as Canada Goose is concerned, I think I should best seek to deal with this by acceding to your lordship's invitation or request to formulate the inconsistency with previous case law in writing, but we
Well,
say
it's got to be overnight. It's got to be before,
yes,
before the others get to address the court. Yeah.
of course. Lord, I am conscious of having gone materially over my allocation. I hope having sought to answer some of the court's questions. I think
You've been subject to questions.
I'm not. I'm only concerned for my learned friends having a fair crack at the whip. Lord, so far as the convention rights aspect is concerned, which only arises if one thinks that's the only narrow exception to the judge's general principle. The judge ruled out against the world injunctions, root and branch on that basis. The advocate of the court, with whom we respectfully agree on this point, suggests the judge went too far. No one is asking this court to reach any conclusion on the facts. All we say is that on the kind of evidence that there is in some of these cases, and must be looked at in any particular case, the Article 8 rights of local residents are engaged. They suffered on the evidence that my client had used, there was very significant disruption to their enjoyment of their homes through noise, including late at night, through abuse, through personal danger, through dangerous driving, and the like. The references are in the skeleton. It is clear from the case law that those matters are sufficient to engage Article 8, and it then becomes simply a matter of balancing those considerations with other relevant considerations, including potentially the Article 8 rights of travellers in the particular case, and crafting an injunction accordingly.
And your A1P rights, A1P1 rights.
Yes, I've been a little circumspect about A1P1 because the property here belongs to the local authority, which has no convention rights of its own.
Does it not have A1P1 rights?
We are told conventionally that emanations of the state do not have their own.
Emanation of state, right.
Although, but one could imagine other final injunction scenarios when A1P1 would be.
Well, it would be absolutely bizarre if a local authority could not get such an injunction, but because somebody else had A1P1 rights, they could.
Yes.
I mean, the court has to behave sensibly. It has to be coherent, the law.
I certainly wouldn't seek to dissent from that proposition.
No, I mean, one of the problems with all this is that at the moment, looking at all these cases, some of which I hadn't seen before, it's the coherence is very distinctly lacking. I mean, let's be quite honest about it, and it's our job to make sure the law is coherent, is it not?
Lord, it is, and coherence here in isolation comes not from the kind of rigid classification that was rejected in the Privy Council case I call broad idea. That just leads to more incoherence. You just have anomalies. Look, the coherence comes from approaching the facts of a particular case and saying, does the claimant need an injunction against unidentified persons? In other words, should it have been able to identify the people it wants to restrain? You need to ask, does the claimant have a legitimate need for an injunction which will bind newcomers? In other words, to put it in very simplified terms, is this a rolling cast case?
Well, that's what's been concerning me, actually, Mr. Gibbon, is that in the furthest reaches of this case, if one reads Mr. Justice Nicklin at face value, it is actually impossible, even in a case where the travellers set out to defeat the injunction by rolling around the putative 12 sites and never the same person on the same occasion being on one site, but they are actually organising their affairs so as to defeat a particular injunction against particular people, it is not possible for the law to do anything about it. And I, having a heightened sense of justice, find that rather difficult to accept. But it is the consequence, is it not?
Well, it is. I'm not sure it's even particularly hidden away in the judgment. It is absolutely what the...
Even if it is deliberate, with the intention of cocking a snoop effectively at the court.
Yes, I suppose, well, would it be cocking a snook at the court? I suppose if an injunction had been granted against named persons, it might be.
Well, if it's named persons, it's absolutely fine, but the whole point is that
yes.
What is suggested is that in some of these cases there are so many people involved that nobody can be identified because they're never in the same place for long enough to be identified. And that does seem slightly strange, that you can't identify anybody at all, but the effect is the same.
Well, Lord, I mean, in our case, we could identify some people, but the evidence explained both why we could identify some people and why in very many cases one...
Well, the point is those people then disappear.
Yes.
The people you've identified know the game's up.
Yes.
And so you're in a continuing rolling situation of not being able to get a satisfactory order.
Yes, and one might have thought about representative proceedings, but the judge, albeit Obiter, has said that's not, he doesn't think that would be appropriate.
You haven't appealed that?
Well, it's we haven't appealed it. I'm not sure we could. It wasn't.
I mean,
there was no application.
You get into a whole other area.
Yes.
If you start using representative proceedings.
Yes.
There's a whole raft of recent authority, including Google in the Supreme Court, about 19.6, which, whilst I might be attracted to it, probably wouldn't be your best bet.
Yes, but I mean, well, that was precisely the point in Blue. That is why, I mean, a major part of the Vice Chancellor's reasoning, Sir Andrew Morris' reasoning, Bloomsbury's, it's hopeless trying to deal with these cases on the basis of representative proceedings. So what we want here is an injunction. But the only point I'm making is that if we can't have representative claims either, it just makes the practical problem, Your Lordship refers to, even worse.
Yeah.
So
I mean, while I'm talking, Mr. Giffen, when you're considering this document that I'm inviting, it does seem to me, looking at this case, that there has been a bit of a sea change in the approach of the senior courts to persons unknown cases. I mean, I remember fondly hearing persons unknown cases in the Chancery Division when I was sitting at first instance, and none of what I'm reading now, with some incredulity, seemed to be argued before me then, and indeed quite the reverse. Everybody was dealing with protester cases where students occupied parts of universities, and the courts were astute to make orders which stopped any students sitting in any part of the university building. And nobody ever said this was a breach of any fundamental rights of natural justice, and off we went and made these orders. And we see that in the history. We see Lord Bingham and Lord Phillips and hearing these cases years ago, and none of this was mentioned. Then all of a sudden there's a bit of a sea change with the more recent cases. So it would be useful to me to look back as well and see where the change came and whether actually the doctrine of precedent was properly adhered to as the change began.
Well, I definitely ought to sit down now, but when we're putting stuff in writing overnight, I will see what can usefully be done by way of perhaps a tabulation of some of the authority it hasn't actually
Yes. I mean, one of the most important things that people never do is to look at authorities in chronological order. Because until you see which one came before and which one came after, you can't see the progression of the law. And the doctrine of precedent depends on that progression. Anyway, I'll shut up.
I have the point. And I'm sorry to everyone.
Well, I stand up now only because it's going to be a while till you hear from me. And there was just one point that I thought may be helpful just to make sure is on the court's radar, which is that in my preparation for this case, it did strike me that the recent authorities from this court can't be reconciled on the face. And I've tried to practice financial on that, and I, in my skeleton, have taken them chronologically and with references to principles of precedent.
Yes.
I've also asked for all of the cases in the main bundle to make sure that they're all in there chronologically by the date of hand-down because of that exercise. So I see you already have the point, but since Mr. Giffen was going to be doing that same exercise, I thought I'd just highlight that, for my part at least, it's done and you have it there if you want to look at that.
Thank you. Yes, Mr. S.
Just give Mr. Giffen his watch back. Lord, can we start by looking at what happened in the Wolverhampton case? The council had experienced in its borough a large number of incursions in a short period of time. And one of the features of that was pleaded in the following way by Miss Caney, who sits behind me today. Attempting to deal with the problem of unauthorised encampments has further had a dramatic impact upon the resources of the police.
So what are you doing? Are you reading something?
Yes, I'm sorry. It's paragraph 30 of the particulars claim at page 163 of bundle 1. I wasn't going to invite the court to go there because it's such a short point, and I thought you'd take it in without...
Well, it's not much help to me unless I can see it on the page, I'm sorry. 163.
Yes.
Paragraph
30.
attempting to deal with the problem. Yeah.
Yes.
Okay.
And that was the game of cat and mouse that Your Lordship has just been talking about, and was part of the pleaded problem that Wolverhampton brought before the court.
Yes.
And if we next go to the judgment of Mrs. Justice Jefford, which begins at page 214, she recites some of the evidence in the latter part of paragraph 3.
Did you say 214?
Yes, this paragraph is at 260.
Yeah.
Where, picking up from 8 lines up, he identifies, that's to say one of the witnesses, in the first part of this year, up to the 16th of April 2018, 21 incursions, as they've been called, had occurred in Wolverhampton, representing the most in any single council area, and 24% of the total in the West Midlands. By the 8th of May, this figure had risen to 25 incursions for 2018, and since the issue of these proceedings, there have been another 14. And she goes on later to say that these incursions cost about £7,000 a time, so that the bill for the ratepayers of Wolverhampton has been quite considerable. Having set out not only the frequency and expense of the incursions, but also the public health risks that they import into the borough, and having come to the conclusion that all of these matters in paragraph 9 weigh heavily in favour of granting the injunction that is sought, her ladyship said at paragraph 10, it is nonetheless necessary for me to consider whether it is just and proportionate to grant such an injunction. One matter that needs to be addressed is whether there are lesser alternatives to such an injunction. I am satisfied that in terms of the efficacy of preventing unauthorised encampments, there is no adequate alternative remedy. That, of course, didn't conclude the matter, because she then had to go on and perform the Porter assessment. In 2002, the House of Lords said that when a local authority seeks an injunction which engages the defendant's convention rights, that it's for the court to have regard to whether it was just and proportionate to grant the relief being sought. And her ladyship sets out in paragraphs 10, 11 and 12 and 13 some of the concerns that she had in this case about the injunction she was being asked to make. Whether the 60 sites was in fact a borough-wide injunction, because there were so many sites and she was satisfied that it was not. Whether there has been a proper balancing act carried out by the council before deciding to apply for the injunction, paragraph 11, and she was satisfied that it had. She cites from Porter in paragraph 12, and in paragraph 13 remains concerned because she is worried that there isn't adequate provision for travellers in the borough of Wolverhampton. But she's been reassured that there is to be a transit camp opened up that will provide a space for them to stop and ends up, after considering whether to grant an injunction for a limited period, does so, but also introduces a review provision so that the injunction will be reviewed after 12 months to enable the court to decide whether to continue it or to discharge it. According to Mr. Justice Nicklin, his sister judge there was performing an impossible task, because he would have it in paragraph 231 of the judgment that it's not possible to carry out a Porter assessment in a person's unknown situation, because he would have it that all that can be done when you don't have identified defendant is a comparison of rival generalities.
So what were the facts of Porter?
Porter was an injunction case where it doesn't concern persons unknown. It concerned whether it was appropriate to take into account, well, it was about section 187B, and whether it was appropriate to take into account the defendant's convention rights and at what stage.
Right.
And that is, it's the Porter assessment that this case is in some ways all about. Because Mr. Justice Nicklin said at paragraph 234, 235, 236, that this, as he put it, parallel assessment of the rights of the claimant on the one hand, often themselves convention rights, but not necessarily convention rights, and the rights of the defendants on the other hand, which are convention rights in this case, have to be assessed. And his point was, if you don't have the defendants before the court, you can't assess their position with any degree of reliability. But
all that may mean is that you can assess their Article 8 rights if and when they come along to discharge the injunction, and that that's the appropriate time to do it.
Indeed, my lady, yes. And it's going to be my submission that this issue has already been perceived and discussed, albeit briefly, in Gamel. And it was this issue, the difficulty of performing the Porter assessment, as I called it, that the court was concerned with in the test case at Bromley.
Because the whole point about the Porter assessment is that the three cases that were before the court in Porter were all cases of identifiable people who had bought land and were repeatedly breaching planning control by living there when they didn't have planning permission to live there.
Indeed.
So in some ways they're completely different cases from these ones.
Yes, but nevertheless the principle which was enunciated in that case, which is that you have to consider whether it's just and proportionate to grant an injunction in such cases, even though there's a clear breach of planning law because of the convention rights of the defendants, that principle does apply in these persons unknown cases.
Well, but that's not what Porter decides. Porter is about people who are identified and whose convention rights the court was in a position to assess.
Yeah, but in Bromley, if it was an extension of the Porter principle, so be it. But it was clearly recognised in Bromley that the courts have to have regard to the potential defendants' convention rights before granting a person's unknown injunction.
Right, well, I think, Mr. Anderson, that may be a good time to break. I know you haven't had very long to get your feet metaphorically under the table, but we'll resume at 2 o'clock.